Committee will go ahead and call the meeting to order. First inquiry of our friends that are online, because it's easy and clever to create backgrounds that make you look like you're somewhere that you're not. I just want to remind members that are online that we will be working bills today, and it is necessary under our guidance to have you present in the Capitol. I'm guessing you all are. You're probably eating lunch, unlike the rest of us. But is there anyone online that's a committee member that happens not to be in the Capitol at this time? Just raise your hand or speak up. So,
Mr. Chairman.
Yes,
Mr.
Dave.
Chairman, this is Representative French. I'm not going on video until I finish this hot dog, but then I'll be right on video.
And I want you to, I appreciate that, Representative French. Your Zoom etiquette, or your whatever this platform is called, WebEx etiquette, is just outstanding. You're not as technologically challenged as some may have asserted earlier. This is good. Good for you. And I appreciate it. All right, so we will move on then with consideration of bills previously heard, and we'll begin with House Bill 2360. Call upon the reviser to refresh our recollection on the content of 2360.
Thank you, Mr. Chairman. House Bill 2360 removes recklessly causing fear or evacuation, lockdown, or disruption in regular ongoing activities from the first element contained in the crime of criminal threat.
And Natalie, just for a little bit of clarification and refreshing people's memories a bit on this, this is in response to an appellate court case that effectively rendered that portion ineffective, having been found unconstitutional?
Yes, Mr. Chairman, the appellate court in that case found that it was unconstitutionally vague.
Committee, you've heard the description of the bill by the reviser. Are there any questions of the reviser? Okay, any questions? I don't see any questions. Are there any discussion or motions with respect to the bill? Representative Day, are you raising your hand now? Do you want to talk about this bill or? Okay, go ahead. Speak up.
Thank you, Mr. Chairman. I didn't know, I jumped ahead of it. Sorry. I know that you probably just want to move on with this one, but I just wanted to make sure I understand. I realize that it's an unconstitutional language. We need to remove it. Is that happening across all states? And I just want to make sure I understand what that means when we remove the reckless part.
Natalie, feel free to jump in if I get this out of whack, which I know you're good at correcting me, but essentially we had a Kansas appellate court decision that said this language was unconstitutional, no longer enforceable. And what that means is that it has no effect, even though it's on the printed page of the law right now. And what we will be doing is essentially cleaning up the statute book so that that language that has been found unconstitutional is not errantly applied by those in the field that have to apply what they find in the books. I hope that's a decent enough explanation. Close enough, Natalie?
Yeah, there are just two things I might add in response to the question. The first are, like other states doing this, each state has a different verbiage in criminal threat. You know, every state criminal code is a little bit different. So not all states might have run into this situation. And just to be very clear, even though, you know, the court did find that this was unconstitutional, there would be many ways that you could go about addressing this. One of them is striking the language, but you could also make an attempt to try to change that language in order to come in conformity with the Constitution. This requester just happened to request that it be stricken.
So in essence, it makes our law more effective is the idea behind removing that language.
Well, and so to kind of jump on what Representative Jennings said, right now, whether you keep this language on the statute books or not, it is not enforceable because the Supreme Court has held it to be unconstitutional. So you're actually not really changing the current status of the law. You're just making the statute reflect what the current status of the law is. Because
Okay,
right now that's
yeah,
not
that
being
is
enforced.
so much more. Thank you so much for that, and thank you, Mr. Chairman. I appreciate the help.
Absolutely. Representative Smith, you have a question or comment?
Yeah, but I'm not going to be very eloquent about it. I'm trying to figure out how to, I don't remember the exact language of the statute itself. Natalie, do you have that where you could, the actual statute?
Yes, Mr. Chairman. And if you look at the bill, that language is contained there in the bill, but I can, I can share it or read any parts of it that you guys are interested in.
The representative has a copy of the bill in his hand now and is reading.
Yeah, I'm thumbing through tabs here on my computer. I can't find it, but I did read it, and it says with intent. It doesn't say intentionally, but with intent, which gives a general idea there. Is that correct, Natalie? Rather than it's not saying intentionally or knowingly, it's saying with intent. How would that be read?
Yeah, so I think that's part of, not that you probably want to read appellate court cases in your spare time, but the court did get into a discussion of that because the first part of that phrase is commit violence communicated with intent to place another, and then, but that second part of the phrase is the reckless portion. And so what we're striking there is the recklessness portion.
Well, I was hoping we had the luxury of having you, Natalie, to avoid having to read all that appellate court, but I appreciate that. Thank you.
Fireside reading, I'm sure. Yeah, absolutely. And other questions for the reviser? Discussion, or what's the will of the committee in terms of this bill or amendments? Representative Heiberger.
Mr. Chairman, I move that the committee recommend House Bill 2360 favorably for passage.
Is there a second to the Heiberger motion? Representative Resman, discussion.
Mr. Chair, you and I had a conversation briefly about what this is going to be about, and I think I indicated to you that I clearly understood what was happening. Now I'm a little bit pulled back on it, simply because I think I would like to see what the general, what the decisions have been on that. When you add recklessly, obviously you just drop the bar quite a bit. When you take that off there, then it leaves it up to interpretation with intent to do any of those specific things if you go with intentionally, or to go, if you were to say knowingly. And we've talked about this. In fact, I think we've gotten a good education on the House floor about now what knowingly versus intentionally is. But the general intent would seem to match also, unless you had a different opinion from the bench in a particular case. I don't know that we solve it by either placing, and I'm not suggesting to you, I'm thinking about doing an amendment now. But it is going to take more thought on my side of things.
Fair enough. Committee, other discussion on the motion? See any hands raised? Representative Heiberger, do you want to close on your motion?
Sure. No, I think it makes sense to me to get language that's been found unconstitutional off the books. I do think there's some vagueness there. I mean, the remaining language supposedly might be clearer, but that can be addressed down the road or in the Senate. But I think the idea of taking the unconstitutional language out is a good idea, and I would move my motion.
Committee, you've heard the motion to recommend the bill favorably. Those in support, raise your hand, please. Motion, those opposed? Any opposed? I don't think so. See no opposed. Motion passes. We'll endorse upon the minutes the affirmative vote of Representative Heiberger, Representative Owens, Representative Carmichael, others wishing to have their vote recorded in the minutes. Thank you very much. Seeing none, we will move on now to House Bill 2361. We'll call upon the reviser to refresh our recollection concerning this bill.
Thank you, Mr. Chairman. House Bill 2361 would authorize the Supreme Court to adopt rules establishing specialty court programs. And then judicial districts throughout the state would be able to operate specialty court programs in conformity with those rules. It also creates the Specialty Court Funding Advisory Committee and the Specialty Court Resources Fund. So the advisory committee can seek out grant funding or other types of funding and then use that fund as a funding source for those programs.
Any questions for the reviser? Seeing none, what's the desire of the committee with respect to House Bill 2361, Representative Owens?
Thank you, Mr. Chairman. I would motion that we refer House Bill 2361 favorably for passage.
There's a motion by Owens, second by Representative Smith. Discussion, committee, any discussion? I would just say I'm pleased that the courts across the state, to the extent they have been able to implement these kinds of therapeutic courts to date, is a good thing. I think they've demonstrated their effectiveness, and in past years, I think it was a year or two ago, we had a couple of these drug court judges that appeared and testified before the committee, and I was personally terribly impressed with the manner in which they conduct their business. It's quite different from the adversarial proceedings that we typically see in a courtroom, and although it still holds people to account. So I'm thrilled to have this bill, and hopefully we can see this replicated in other jurisdictions. Committee, Representative French.
Thank you, Mr. Chairman. My first question is, I was wondering why this particular bill was put into our committee. To me, it looks like it ought to be in Judiciary. The Specialty Court Funding Advisory Committee has members of the Judiciary committees on it. So it seems like they would be the ones involved in doing this bill. So I'm a little concerned of the fact that this seems to be out of our area of maybe not interest, but knowledge. I know I'm not particularly up on being able to support this. I've tried to find out exactly what specialty court means, what it is. I've looked considerably, but at this point in time, I'm not ready to give a yes or no on this. So with your permission, Mr. Chairman, I will be only voting present on this bill, and I'll guarantee I'll get smarter on this next session. Thank you, Mr. Chairman.
Representative French, good to see you finished the hot dog, and I appreciate your comments. In terms of where bills land, in the end, that is the choice of the speaker about what committee are assigned what bills. While bills might be introduced in a particular committee, it doesn't mean they have to stay there. He has full authority, and for whatever reason, it came here, and we just kind of do what we're asked to do when we're asked to do it, I guess. So that's just a response to that. Representative Carmichael, you have your hand up.
I do, Mr. Chairman, if I can be recognized.
I recognize you.
I recognize you as well, Mr. Chairman. Thank you. I think I ought to mention that when we heard this similar legislation a year or two ago, Judge Nick St. Peter from Winfield came up and explained to us in detail how these courts truly make a difference in people's lives. And my recollection is he was speaking principally, I believe, of drug courts. In addition, my good friend, Judge Tim McCarthy over in Johnson County runs the Veterans Court over there. where they try to give special attention to military veterans who have difficulty in reintegrating into the community following what they've seen and what their duty is required of them in serving our country. And Judge McCarthy can tell you so many wonderful stories about people's lives who have been changed and redirected because of specialty courts, courts that are aware of the difficulties. It is important. The third thing I would suggest to you is that one of my constituents is the public defender at our drug specialty court in Wichita. And it's amazing to sit and have lunch with him and explain how he can explain how a holistic approach to dealing with people with substance abuse problems, not in an adversarial way, but rather in a constructive and helpful way, once again, can save people's, not only save their reputations vis-a-vis criminality, but literally save their lives and allow their families to have a helpful and supportive spouse or parent. These courts are an absolutely excellent idea, but I will confess to you, when I first heard about specialty court, I thought it was not necessary. I thought everyone ought to be treated the same, and we drag everybody in for a docket call and take their pleas and send them on their ways. These courts are an outstanding idea, and in the end, save society trouble, inconvenience, money, and reroute people away from corrections and into rehabilitation. This is an outstanding opportunity for us to do good. Thank you, Mr. Chairman.
Thank you, Representative. Any others wish to speak to the bill? We have a motion and second for favorable approval. You want to close?
Sure, thank you, Mr. Chairman. And Representative French, I can tell you, serving on judiciary as well as corrections, I have thought the same thing on many occasions this year, seeing some of the bills that went there versus here and vice versa. But I definitely echo the comments of the good representative from Sedgwick on the importance of these courts. And with that, I move my motion.
Committee, you have a motion and second to report favorably House Bill 2361. Those in favor, raise your hand, please. Those opposed, same sign. Very well. Appears the motion passes. Those wishing to have their affirmative vote recorded would include Representative Heiberger, Representative Owens, Representative Carmichael. Pass for Representative French. If I'm incorrect, Representative, let me know, but I believe that's what you articulated earlier, and we'll show that.
Thank you, Mr. Chairman.
Absolutely. And any member wishing to have a no vote recorded? Seeing none, we will move on now to next item of business, which would be House Bill 2349. We'll call upon the reviser to refresh our recollection about this bill.
Thank you, Mr. Chairman. House Bill 2349 creates a mechanism to seek relief from the Kansas Offender Registration Act. It also decreases the criminal penalties for violation of the act. It allows courts to waive fees associated with registration under certain circumstances. It reduces the number of places a person is required to register, and it also eliminates registration for most juvenile adjudications. And I can take any questions.
Committee, any questions for the reviser? I see none. Committee, I'm going to ask that an amendment be distributed to the members that I've asked to have prepared for today. I'm going to give that a moment or two to to be distributed, and then we'll discuss the elements after the reviser tells us a little bit about what this amendment purports to do. It might be a wise first step, and then have a little conversation from there, Natalie, if you would.
Sure, Mr. Chairman, the big points to look at on this amendment, the new section 1 process for having fees waived right now, an order ordering modification to their obligation to pay that fee can last for 3 years. This amendment would change that to 1 year. It removes the portions of the bill that get rid of juvenile adjudication registration. So juveniles, under this amendment here, juveniles would be required to register just as they are under current law. And then we do make some changes to the penalty provisions, which I believe are on page 25 here. So that would be a big page to look at, but those are the big changes that we're making here.
Thank you, Natalie. I'm going to kind of pick it up from there and just have a little conversation with your committee about this amendment. We, of course, entertained testimony on this bill, and you know, I guess in my mind, the testimony that we heard from proponents certainly probably was among some of the best, not to be critical of others' testimony, but I thought their testimony and presentation was pretty solid and represented a long, hard study of offender registration in Kansas, and it's a difficult issue, and there's lots of moving parts. Essentially what this amendment does is just takes all those references to juvenile registration out, with the idea that we may revisit that next year, but that it overly complicated and I think made this a bit more of a difficult issue to work through in a short period of time. It does get into kind of, and Natalie, feel free to correct me if I misstate any of this ever, as you, I'm sure, have a propensity to do anyhow, and I appreciate it. And this was in discussions, too, with our law enforcement friends. You know, we know that the sheriffs, chiefs of police, and KPOA had some concerns. I engaged with those organizations through their representatives, and believe that this amendment, while there's certainly at least one issue outstanding that is not resolved and is one that may be of some concern, but that this amendment was something that they could support, that they thought this did a lot to improve the bill in a way that they would not just be outrightly opposed to it, and it does several things. I think one of the things that's noteworthy is that we had some conversations during the testimony about, I think it was Representative Humphreys may have brought up the guy that had bought a boat or something and failed to go ahead and put it on his registration that he had this boat. There's to me at least, and I think to many perhaps, there's a big difference between not telling somebody about a jet ski or a boat and not giving somebody your street address where you're living at, or being deceptive or lying about that. So we kind of split these out into a very substantive registration violations, such as failing to report where you're living accurately or at all, and those kinds of things, versus the more technical side of things, and made those offenses of non-registration treated a bit differently in terms of penalty. You know, obviously the non-registration of your home, where you're living, where you're working, where you're going to school, that's physical location. That's a big deal. Your car, your new tattoo, your boat, probably not as big a deal as where you're living or where you're going to school or working. We did return to really the notion that we're not going to wait a year in terms of those aggravating registration issues, that it'd be back to the, it'd be 180 days as it was, so that doesn't get changed. We continue to retain single point registration in this, and that actually, as committee might recall from last year, that idea was actually kind of floated by Sheriff Easter in his testimony, I think, a year or two ago. There is no guarantee that that single point of registration will meet the federal requirements of Sex Offender Notification Registration Act. If you read the guidance on that, it might not. We won't know until we know. And about the only way to find out for sure is to go ahead and pass something, have them review it, and tell us either we're in compliance, substantial compliance, or compliance or not. And as we know from the testimony, at risk in terms of funding would be maybe $180,000 of burn grant funds. It's interesting, as I've researched this and asked research to do some work for us on this, those funds end up basically going into a trust account. If you become non-compliant, it goes into a trust account, which can be recaptured at a later time and used towards achieving compliance with Sorna. One would think maybe that lots and lots and lots of states are in full compliance. That's not the case. I have two pieces of information that are in conflict, and unfortunately they're both from sources that I trust, but it looks like it's somewhere between 12 and 18 states that actually achieve this full compliance, and that there's perhaps as many as 30 states who have not and have that money either go into that trust for use to gain compliance, and several who've just said thanks but no thanks. So there are components of the amendment that we have here that will tip us even more out of compliance than the question of single point registration. The other kind of, I think, penalties, contemplated that you can't have a penalty of less than 1 year for non-compliant behavior. Our sentencing grid for these levels doesn't get us to 1 year. You know, at the levels that are contained in here, and certainly misdemeanor violations are not going to be greater than 1 year. So those are technical. I mean, they're close calls, but they're technically they would be probably potentially anyhow non-compliant. Trying to think of the other components here that could be. Oh, so the exit strategy. This is actually this is about the oddest thing you can imagine. There's 3 tiers in SORNA offenses: Tier 1, 1, 2, and 3. The middle tier would be kind of our mid-range of registration requirement. I believe it's 25 years. There is a provision in SORNA for relief from a lifetime, as I recall, and a relief from a 10, but you can get no relief from a 25. Now, I don't know what the logic is behind that at the federal level. Our bill would provide for the offender's ability to make application to the court and have those findings made that they don't present a danger, they've been compliant. That's probably going to tip us out. I don't know. I mean, I guess I don't get the logic behind that mid-tier one myself, but that's just the way it is. My guess is we can't do anything here to change that. But I think that was one of the more compelling pieces of this, was giving people that opportunity to perform, to do what we ask them to do, to create an incentive for their registration and compliance. And when they do that for an extended period of time, they have an opportunity to go to court and say, I've done everything you asked, I'm not a problem, I'm not committing new crimes, I've gone through treatment, whatever it's been, and then get on with their lives. And so I guess what I would say is the SORNA piece applies, you know, particularly to certain crimes. We have a few crimes that we probably have a few crimes that we require registration for that we don't need to, and we may be eliminating a couple that they think we need to. So all I can say is, in the end, someone will review it. We can seek and ask for kind of an advisory opinion from the SMART office in Kansas through with the feds to see how far out are we? Is there something that they you know, is it going to tip the $180,000 question or not? I'm just saying there is no clear answer today. That would be at risk, and I would say that having been involved in that judicial council process, this is substantially dialed back from what their recommendations were to start with. We found the middle ground in terms of trying to get people kind of on board, but they well understood that this would make the state non-compliant, and I don't think myself. I'm not sure I agree. The mid-range people, for instance, you know, you can't. I don't get it. Let somebody with a life able to petition.
Mr. Chairman, we can't hear you online. You're getting too far from your microphone.
I'm sorry. How's that? Better?
Much better.
Wonderful. Thank you, sir.
Sorry about that. Yeah, I will. I will answer questions when the time is appropriate. That's probably about Tuesday. So I'm just saying I don't think there is a perfect to be attained at this point in time out of this, but it does not foreclose the potential of change as we go forward, whether it be House floor or be Senate, but we're up against a deadline at this point that there's not much else to do but to say, here's an amendment that law enforcement, I think, is behind and supports, and one that I think moves us in a more thoughtful direction in terms of how we manage these folks, and I just leave it at that. So I've got the motion's been distributed. You've all have had a chance to look at it. I'd ask if there's a second to my motion to amend. Representative Heiberger seconds. Discussion on the motion. Representative Carpenter.
Thank you, Mr. Chair. So I just want to make sure I'm understanding the amendment before we have to vote on it here. So there's a number of balloons. It seems like a lot of it's just adding language back in. And I'm guessing that was the compromise that you're referring to, that law enforcement. So we were basically just going to, it was amending that language in current statutes, but now we're going to just bring that language back in to match the current statute. Is that correct?
That would be partially correct. Pulling out all of the juvenile components, which are just kind of a bizarre set of circumstances themselves, rather than trying to fix that part at this point, we just take out all the changes for juvenile offender registering. So that remains the same. The second parts we had the conversation with our friends in law enforcement went to penalties. So the penalties in the original bill were like all misdemeanors. Now it's set up where on a misdemeanor, kind of an offense, underlying offense, I guess, you're going to have a couple misdemeanor bites at the apple on your first and second. Third one would go to a felony on felony level offenses. You're going to be hit with a low level felony. Probably the biggest thing is they're non-person. So currently they're person felony designations for much of this, which really contributes to very significantly to a future penalty potential under the sentencing grids. They're a weighted offense, and the testimony that we heard, and I think what this committee that made the recommendation to begin with grappled with was there's no victim in not reporting your registration. There's no person involved. You simply failed to do what is a civil obligation under the law, and that a person felony just didn't make much sense. If they go out and hurt somebody, then they're going to get charged with the person felony for hurting somebody, but the registration piece itself just didn't make sense to get there.
Okay. Thank you, Mr.
I think
Chair.
that's it. Natalie, is that enough of coverage on the representative's question?
I believe so. All the language reinsertions that we're making are related to the juvenile adjudication portion, I would note, just to be super clear, that in that exit mechanism that we're creating, as originally drafted, we didn't apply that to juvenile adjudications because they would no longer be required to register. But we did make clear in that new exit mechanism procedure that juveniles would be added and would be eligible to apply for that.
Mr. Chairman.
Other questions or discussions on the motion to amend? Representative Heiberger.
A question and a comment. It's my understanding that there's a waiver provision in Sorna that if we are not completely in compliance with the Sorna requirements, that a waiver could be applied for. Is that accurate?
I'm not sure that waiver is the correct terminology. I believe you are asking essentially for approval of substantial but not total compliance. And I believe that's the distinction. I'm not sure. I can go back to an email I have here and maybe give you that exact language. It's very much like a waiver, for sure, but it's not exactly that terminology.
Well, so I sat in on quite a few of the committee meetings because I was following a different bill, and I was really impressed with the work that went into this. I mean, there was real back and forth discussion. I mean, as Judge Sexton pointed out, it was a committee with really broad representation, and they took this issue seriously and they worked hard on it. So I'm disappointed to see changes on what's coming out of the committee. If it's what we need to do to make any what I consider to be progress, I'll support it. But especially the juvenile registry, a lot of those terms are really, I think they're really out of line, and I think they, just given the, I mean, I had this misconception before I sat in on those committee meetings about recidivism rates for sex offenders in particular. I mean, data really shows that they are vastly lower than for other crimes, and for juveniles even lower. I mean, there may be some tiny category of sex offenders that repeat offend, but the overall numbers are really small. And so these sanctions, I mean, the registry is not supposed to be part of punishment. It's supposed to be a civil mechanism to help protect public safety. And I think there's very little evidence that it does so. So I support the changes. I'm glad we're keeping at least some of the reduction in penalties because the onerous reporting requirements in this statute are really driving a lot of our prison population by probation revocations. So again, I wish we could do more, but I would support the amendment.
And maybe back to the question about waiver and substantial compliance. The issue is described, as I understand, to be substantial implementation, that there's a report that would indicate that the states deviated from substantial implementation, and that the feds can make a finding that the deviation does not substantially disserve SORNA's purposes. So it sounds to me like perhaps it's a bit of a subjective test that's applied to see, are you doing things that achieve the desired outcome of the whole business to begin with, or not? And there's probably some red letter stuff there that they may not accept. I think that's, I'm not going to minimize it. I think that's a real risk, but the question ends up being, do we, I think ultimately, do we just want the federal government to tell us what our state's policy is going to be? And if we're going to do that, then let's do it uniformly around every issue that comes up, and that makes life here a whole lot easier. Further discussion or questions? We've got Representative Carmichael.
I believe Representative French had his hand up before I did, Mr. Chair.
There we go. I do see Representative French now. I haven't scrolled up quite far enough. Representative French.
Thank you, Mr. Chairman. And I don't care what order you take me in. I just appreciate you acknowledging me. I tend to agree that this amendment that you're offering is an improvement to this bill, and I will support it. Although even though I believe that changes probably need to be made in the registration process, I do believe this bill is gone too far, and I will be voting against it even with the amendment. Thank you, Mr. Chairman.
Thank you, Representative. Representative Carmichael.
Thank you, Mr. Chairman. As I know the chairman is aware, I greatly respect the chair's knowledge and opinion and good judgment. But I must have missed something here, and it's my fault. But what is law enforcement? It's just perplexing to me that we would at least partially reform adult registration and yet leave the inequities and just a number of things unrepaired for juveniles. And I think I understood the chair to say that Kansas law enforcement is objecting to this for juveniles. Can you help me articulate, frankly, why I should be voting for this amendment? Because I must have missed it somewhere, and I would appreciate the chair's help.
Absolutely, and I would respond in this way. What I instructed the reviser to do was to eliminate that all references to juvenile, because the complexities of the juvenile piece were such that being able to get those resolved with or without law enforcement's involvement at the table and discussing it was going to be such that we wouldn't be able to be considering this in this session at all. And that I would commit to having a bill introduction next session that's focused exclusively on the juvenile piece at a time that we could dedicate a day or two of hearing time to hear from people where we got kind of jammed up on time, Representative Carmichael, on this one. And it's been in the mill a long time. It took a while to finally get it finally drafted, finally printed, finally delivered and on the calendar. And this seemed to me to be prudent to cull that piece out. That was not at anyone's request other than my own. And it had more to do with the available time and complexity of the issue, not that it's not an issue worthy of discussion. It's more a matter of time. So if I've led you to believe that it was law enforcement that said take it out, it wasn't. I told them that I wanted to take it out, and they were agreeable so that we could have a more robust conversation about how do we deal with the juvenile. As you know, there's so many different factors involved in this juvenile piece that the adult piece is complicated enough, the juvenile piece gets worse.
And Mr. Chairman, I appreciate you correcting my misunderstanding that this was somehow taken out of law enforcement's request. I want to see the bill passed, and I recognize the practicalities and that the perfect is the enemy of the good. But I'm going to have a real hard time going back to my district and saying I voted to reform offender registration for adults that did not do so for children. And so my hope is that the chair has the votes to successfully carry out the well thought out strategy without my assistance. And should the amendment come up short of votes, please give me time to change my vote if that's what it takes to get this done. This is not going to be well received in my particular neighborhood of my community. So, and I do appreciate the chair's efforts. Thank you.
Any further discussion, Representative Wheeler?
Thank you, Mr. Chair. Just very briefly, if you can, I have heard you mention several times, due to the complexities of the juvenile issues, I felt it best to take it out. Can you give me some idea what you perceive as the perplexities of the juvenile issues?
Sure. I think one of those relates to the Sorna business. This was going to be tipping us so far out of compliance, there would be no question, there'd be no rehabilitation to where we would get. You've got a situation in in juveniles where you've got cohorts, and we take care of it in this one, for instance, where juvenile is certified as an adult or treated and prosecuted as an adult. They're subject to the adult provisions of this versus kids who commit the same offenses as someone under the age or not certified. They get, some very different treatment, both in terms of duration and publicity. So we have some cases that judge can say are public and the judge can say they're not. And we just wanted to try to clean it up and make it a little bit easier to separate. That's all this was about.
Thank you, Mr. Chair.
Committee, further discussion on the motion? I do not see any. On the motion to amend, those in favor of the motion, well, I close. Those in favor of the motion, raise a hand. And those opposed? Okay, it appears the motion passes with substantial majority. Those wishing to have their aye votes recorded would include Representative Heiberger, Representative Owens. Any other aye votes wishing to be recorded? I see none. No votes. Representative Carmichael will be registered in the minutes as having voted no. Any other no votes wishing to be recorded? I see none. We are back on the bill as amended. Are there further amendments or discussion regarding House Bill 2349? Representative Carmichael.
Despite the amendment, I am very happy to support this bill. It is genuine progress. Thank you.
Representative Owens.
Just wanted to clarify, because I always respect the opinion, and I love it when people get together and able to work on legislation and make it good. But this product came as a result, especially with your amendment, of law enforcement. So is law enforcement now neutral on the bill, or are they in a supportive capacity on the bill?
I could pull up my email and read the response, but given Mr. Klump's here, I guess I can say my understanding is that they were accepting of the amendments, saw it as an improvement to the bill, still had concern about Sorna, I know that, but otherwise not objecting. Is that fair to characterize it that way, Ed? Or I could read the email.
Chairman Ed Klump, representing the Kansas Association of Chiefs of Police, Kansas Peace Officers Association, and Kansas Sheriff's Association. You accurately described our position. There are still concerns within this bill, but this certainly addressed some of our biggest concerns, especially those with the huge reduction in penalties that were in the bill. And we think it vastly improves the bill, and it certainly lightens our opposition to it.
Thank you. Representative Heiberger? Oh, Representative Carmichael.
I take it then from Mr. Klump's answer that Kansas law enforcement still opposes the bill?
I think he'll be happy to clarify.
It's hard for me to stand up here and say what the associations are going to do with a particular bill. We have a process we follow that establishes our position. I certainly went back to the associations and asked their opinion of this. They were in favor of this amendment. And if you read our testimony, there were some other areas that we had concerns with. One of those being in the juvenile area, that by this amendment is kicked down the road to discuss later. So we could certainly take that off the list. The Sorna issues, I think, are the big ones right now. And I think the biggest ones, and I said in my testimony, I can't remember whether it's in Sheriff Easter's also, I think it might have been, that we like the exit mechanism. We like an exit mechanism. But Sorna has guidelines for exit mechanisms, and this bill exceeds the time reductions over those that are in the Sorna bill. I think the chair did a good job of explaining those earlier, and the concerns with the 25-year is something Sorna says you can't put on an exit mechanism. So, I mean, there's still things that are concerning this bill, but some of the biggest ones that you heard the sheriff speak about, well, I spoke for the sheriff on, is in his written testimony. And the things that we brought up were the penalty reduction levels, not that they were reduced, but the level they were reduced. Sheriff Easter was concerned about the 3-year consideration by the court for indigency, and this amendment took care of that issue. And so a lot of the things we were voicing concern with has been addressed in this amendment, but not every single one of them. So I just can't stand here and say with certainty that because of these amendments, the associations are going to tell me they're neutral, or they're going to tell me, no, we're still opposed to it, because we just haven't had an opportunity to have that full discussion yet. But we certainly thought the amendments were a step in the right direction to provide some balance and consideration of our concerns that we voiced in our testimony.
And if I might, Mr. Chair, I think it would then be fair to assume that should this bill make it through the process on the House side, that Kansas law enforcement will have an opportunity to give the amended bill its consideration and hopefully inform our colleagues in the Senate with a little bit more definitive judgment. I certainly understand Mr. Klump's situation, and I appreciate his assistance to our committee. Thank you.
Representative Heiberger.
Thank you, Mr. Chair. I don't have any questions, Ed. So, but I am going to respond to some of your testimony yesterday, though. And there was concern raised about the pendulum swinging too far and then swinging too far back. But I think we heard testimony that the pendulum swang very far in 2011. And the way, as far as I can tell, we're not, it's rather than swinging too far the other way, we're not even back to where we were in 2011. So I guess that's why I'm concerned that we can't make a little more progress here. And just the issue you just raised about the 3-year time period for indigency, you know, so again, that's something I'd rather keep in. So instead of maybe somebody getting away with something that they could actually afford in the second or third year, we're just making adding more work for our judicial system, which is already overworked. And you know, given the backlog, I mean, will a year from now there be able to be a hearing on a waiver request? So again, I'm not really happy with some of the amendments, but I will still support the bill as amended.
Committee, further discussion? Now I've adequately lost, we're at a point of motion to do something with this bill? Okay. Is there a motion? Representative Heiberger.
Mr. Chairman, I move that the House recommend HB 2349 favorably for passage as amended.
Is there a second?
Yes, Mr. Chairman, there is a second.
Representative Wheeler, I see your hand up as well. You may have had your hand up electronically. Are you a second? muted. I will take Representative Carmichael's second. Put your hand down, Representative.
Well, I would
Wheeler.
absolutely defer to my senior and learned colleague. I would much prefer to see his second on this than my own.
He's waving. There. Representative Wheeler, can you talk now? I think you can.
Yes,
There you go.
I second the motion.
There you go. We have a motion and a second. Any further discussion? Committee, there's a motion and second to recommend House Bill 2349 as amended favorably. Those in favor, please indicate by raising a hand. And those opposed, same sign. There you go, okay. Oops. So Representative Keither, I've seen your hand going up and down and up and down. Are you voting yes or no? Thumb up or down? Okay, that's good, thank you, I can understand that. It appears the motion passes. Motion does pass. Yes, Representative Carpenter.
Thank you, Mr. Chair. I just wanted to ask my vote be recorded as present, please.
Representative Carpenter will be recorded present. Representative Heiberger, recorded voting aye. Representative Owens, recorded voting aye. Representative Carmichael, recorded voting aye. Are there any others wishing to have their affirmative or negative vote or present vote recorded? See none. We will have the minutes reflect the voting as desired by the members, and we'll move on to House Bill 2346 for our last item of work this afternoon. Natalie, would you be so kind as to refresh our recollection about the contents of House Bill 2346?
Thank you, Mr. Chairman. House Bill 2346 allows release of defendants to a pretrial supervision entity or program. And it also allows the fees that are collected in connection with that supervision to be deposited in the non-judicial salary adjustment fund at the discretion of the chief judge in each judicial district.
Any questions for the reviser? See none. Discussion or any amendments? Representative Carpenter.
Thank you, Mr. Chairman. So I guess I'm pretty new to this committee, and as you, I think, eloquently stated earlier or a few weeks ago, it definitely takes some time getting used to this topic when you're not in this profession, and it's definitely a different area of the law that I'm used to. That being said, in my opinion, I feel like this is creating a situation where they will be incentivized to try to obtain as much money as possible in order to help facilitate pay increases for non-judicial staff. And I would hate to see that happen. I think that non-judicial staff do need, pay raises. I just don't want to see those funds raised in that kind of a way. So that's just where I'm at, committee, and thank you, Mr. Chairman.
Thank you, Representative. Representative French.
Thank you, Mr. Chair. Yes, there's a lot of things about this bill that concern me. I hope everyone had a chance to actually read the testimony from the Kansas Bill Agents Association. They laid out a lot of issues with this that I have to agree with, and so I will be voting no on this bill. Thank you, Mr. Chair.
Thank you, Representative. Other representatives, any offer of amendment? Representative Owens?
No amendment, Mr. Chairman. As you're well aware, I work closely with OJA and the Pretrial Justice Task Force on this, as well as having tried to connect them two to actually work on some kind of compromise, which apparently didn't happen. So with the chair's permission, it is my intent to abstain from a vote on this one.
Very well. Appreciate that. Other discussion, committee? Are there any amendments? What is the committee's desire then with respect to House Bill 2346? Are there any motions? Representative Heiberger.
Mr. Chairman, I move that the committee recommend House Bill number 2346 favorably for passage.
Committee have heard the Heiberger motion. Is there a second? See any second? Any second? Oh, Carmichael, Representative Carmichael, you wish to second the motion?
If necessary, Mr. Chairman, I would prefer someone there in the room do it, but if not, I'm available.
Well, okay. You, Heiberger motion, seconded by Carmichael. Discussion of the motion. I would just offer this. I understand that there may be an appearance in some minds that these fees could lend itself to an appearance that somehow the court is doing these things to generate revenue for the court itself, which would be a really bad thing. I do think that goes directly to a point that has been ongoing in this state for a number of years now, not just in recent years, but for a good long time. The whole notion that our court system has become so dependent upon fees for anything, the same argument can be made for every single fee that's assessed. They're having to serve themselves through fees and assessments to sustain operations at a level that they can even meet the demands that hit their system. And they do this in a lot of ways. This one would be fees around community supervision for those on pretrial release. They do it through filing fees. They do it through assessments and fees for supervision, fees on probation, and community corrections gets assessed fees. You know, the judicial branch is just feed to death so they can survive because they don't get enough money from the state general fund to operate in the first place. I totally understand the argument, but if we're going to make the argument that the appearance of fees is bad for the courts, then we've got to go ahead and choose to adequately fund the courts directly to get them off the fees. It's an endless, otherwise it's going to be an endless cycle. They're going to be back year in, year out. I think, frankly, it's unfortunate we're at that point and that the resources are such that they struggle. And I have total respect for the bail agents and their concerns, I guess. I can't imagine, and I did this for a while.
We can't hear you, sir.
Yeah, I'm sorry. I can't imagine, and as I expect some, if not all of you know, at one point in time, I set bonds for people and decided whether they got out of jail on pretrial release for every crime from, no driver's license on up through homicides. I set bond amounts and conditions and all kinds of things. And I guess the suggestion that a judge would be motivated by a $15 a week fee collection to put somebody out on a non-surety bond is about the most absurd thing that I've ever heard. That just doesn't happen. Courts don't put the public at risk and or compromise the likelihood of the accused appearing for future proceedings by establishing bonds or supervision in a way that would avoid a corporate surety bond. It's not uncommon at all to have corporate surety, cash or corporate surety bond requirements on offenders that are not likely to appear or serious offenders. Happens all the time, and sometimes those happen with conditions. They're then still monitored and supervised. I just kind of find it amazing. But, you know, that being said, whatever the will of the committee is what the will of the committee will be. If this doesn't, you know, if it doesn't go anywhere this year, I guess that's life. I'm sure we'll have a chance to revisit it, and there'll be some time to work out kinks if they can be worked out. But I just had to say, when I hear this business about concern about fees, yeah, they've got a concern about fees because they don't have enough budget to run the place. And that's a problem. So there you go. Anybody else? I see none, then, oh, yep, Representative French.
Yes, thank you, Mr. Chairman, and I have to agree with you totally on that they're probably having to survive by fees alone because we have basically not provided them enough funding to adequately handle their responsibilities. And your understanding of the system is much better than mine. Based upon that, I am going to probably vote for this. Thank you, Mr. Chairman.
Thank you, Representative. Further discussion? I don't see any. Representative Heiberger, you can close.
I close and move my motion.
Motion's been made and seconded to advance House Bill 2346 favorably for passage. Those in favor, raise a hand, please. And those opposed? It appears the ayes have it. The ayes do have it. Bill will be so reported. Committee, thank you for your time and attention.
Mr. Chairman, would you
Yes.
please record my affirmative vote?
I'm sorry, your affirmative vote?
I voted for this and I seconded it. Yes, sir.
We will record your thumbs up vote, Representative Carmichael, and that of Representative Heiberger, and we will reflect Representative Owens as not participating. And anyone else wish to have either their affirmative or negative vote recorded? I don't see any. Committee, again, I want to thank you for your time and your efforts this first half of the session. We will get back together sometime after our 2-day break in March, and we have one bill that did touch appropriations that's going to make Representative French think he should have been on probably some budget committee or building committee, but that's okay. We'll have a hearing on that bill and any others that come our ways, and wish you all a safe weekend. And we will deal with, no meeting tomorrow, and we will deal with our minutes when we come back after the break. Anything further? Thank you all. And good job today, Representative Potter. Good job.